I enjoyed the advocacy and the trial end of it a lot more.
Well, one of the things I want to, you're talking about, say, $100,000 to litigate a family law case in Los Angeles, and you also said how much is it going to cost? Well, you take your net worth and divide by hourly rate, and that's how long it's going to. I wanted to get to this idea of what you perceive practicing family law. If you felt that there was a thing sometimes referred to as agency costs, which is basically the opportunity for financial gain kind of biases the advice that lawyers give. Not you, but you've seen perhaps the way that the litigation unfolds, the advocacy unfolds. It is a function of am I going to get paid? It goes on longer if there's a bigger pot of money to fight over.
You know, actually, that's a great point because you hear that a lot, and I actually don't think that it's true. I think that the people who are accused of that are the people who that open letter from the divorce lawyer is describing. That if there is the money to do it and the client wants to do it, I've been doing this too long to fight with you about it. I'm just going to do what you're asking me to do, and I'm going to hang my hat on that. The other thing is there's a lot less risk as a lawyer if you don't advise settlement and that you do go to trial, because then it's the judge's fault. It's not your fault. I mean, we'd have clients who would just lose in court. I mean, just, devastated, and they'd be like, you were such a great lawyer. That judge was really an idiot. And so the chances that you end up with an unhappy client after you've just told the court, like, what a great person this person is and how, steadfast and true they were, and what a great spouse and a earner and doing all this stuff and what a great parent, blah, 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 the client loves you. And so there's this unnatural push and pull, which is, one of the other reasons I got out of that particular part of the business, but that there's an awful lot of pressure to do stuff that costs a lot of money. There's probably people who really just take the hourly rate and divide, take your net worth and divide by the hourly rate. I think, though, it ends up being something that's more backed into, that if there's a lot of acrimony and you're hell-bent on fighting, and there's the money to do it, I'm not going to win with you by telling you, Bill, this is really not in your best interest. 3 months from now, you're going to wake up and you're going to say, why did we do that? 5 years from now, you're going to say, I can't believe I financially devastated myself and my family. You can't hear that then. And so you're swimming against the tide, really.
So how do we end up in mediation versus hiring Diane Mercer, the advocate, to make me kind of win on my sense of acrimony? I'd like to put my spouse in their rightful place, but I ultimately conclude that for one reason or another, I end up on your doorstep as a mediation client versus an advocacy client. How would it play out differently?
In Los Angeles, I don't know if it's true in other markets, but there's really two kinds of mediators. There are mediators that are, let's say, older maybe is wrong, but more experienced lawyers who kind of grew up legally in the community, and so they get referrals from other lawyers who are about their same age, who they remember from the trial days, and now this person happens to be doing mediation as sort of a quasi-retirement sort of ramp-up strategy. Our practice is not at all like that because I didn't grow up, so to speak, in my practice in California. So our mediation practice is almost exclusively direct-to-consumer, which has been its own challenge because public education and marketing, direct-to-consumer, is very labor-intensive, expensive, time-consuming, and sometimes effective, sometimes not so much. I think we're enormously blessed, though, because our clients are really great people having the worst day of their lives. There are people who are trying to do the right thing. They've self-selected into mediation. People will ask, oh, do you do domestic violence, and what about these high conflict cases, and the Department of Children and Family Services is involved. You just don't see people who self-select into mediation and who aren't represented by counsel in a private practice setting who fit those descriptions generally. Probably the depressing part of it, I mean, if you guys are probably not familiar with John Gottman's work, he's a psychiatrist who does a lot of research about what makes up a successful marriage and what makes up a marriage that fails. And one of his categories of marriages is low conflict, low satisfaction. So my sense is we see a lot of these low conflict, low satisfaction cases. It's not that people, and the heartbreaking part of it is you think, well, if these people can't make it in their marriage, who can? Because we see really nice people having the worst day of their lives. And so sometimes they're doing the right thing, sometimes they're not doing the right thing, but generally they're always trying to do that.
So we end up at your doorstep, me and my wife end up in your office, and what's the first thing would happen if my wife and I, we're deciding to get a divorce, we're good people, having the worst day of our lives. Well, what would be how would the first interaction different than, say, for a potential mediation client versus a family law client under the traditional system?
Well, in the traditional system, you'd probably come in for an initial consultation and you'd come in by yourself. In our office, you'll come in for a mediation orientation, which is basically the initial consultation, but you'd come in together with your spouse. That's our first litmus test of whether you're really interested and whether you've actually spoken with your spouse about this. And those orientations are free of charge. They generally last about 30 minutes, depending on the number of questions that people have, and they follow a pretty set outline. Really, we just start with what people's questions are, because nobody can listen until they've had whatever it is on the top of their head answered. So you always want to start whatever consultation you're doing with, tell me what you're interested in finding out, or do you have questions? We always assure them that we will get through the entire outline, but let's start with what their concerns are first. And that's not all that different than initial consult. The big difference is that we don't give people legal advice, and we certainly don't get that started in an initial orientation. Because what ends up happening is people want to tell you their story, and if you get them started telling their story and you aren't going to finish and they haven't yet committed to mediate, and you've only got a half an hour with them, really all it does is open up Pandora's box. So we keep a lid on that in terms of, if you were to become clients, then we would absolutely answer all of these questions. The interesting thing about mediation is you can answer the question in a much more global way, because you're going to be giving both sides of any legal question that they ask you in an informational way. You're giving them both sides of the argument. If I was your attorney, I would argue this and this and this and this and this on this issue, and if I was your attorney, I'd argue this and this and this and this. Both are pretty good arguments. What do you think? How do you think this ought to shake out? How do you think you ought to divide up this asset, given that you've now heard both sides of the same coin? The problem when you go in for an advocacy situation is that there's a lot of pressure just to tell people what the best possible scenario is. And there's a lot of pressure not to mention, well, you know what, sometimes there's this set of cases that goes the other way, and maybe you end up giving up 70% of your income for support because you're underemployed or something. That if you tell somebody that in a first consult in an advocacy situation, you probably will lose them as a client. So there's a lot of pressure to kind of do the wrong thing and not tell about the whole spectrum. But in mediation, it's a great thing to do, because what you do is, throw enough stuff in the air that people understand the vagaries of the law. It was, I think Roger Dworkin said, when I was in law school,
He just retired last year, unfortunately.
The vagaries and inconsistencies of the law are the reason that you'll always be able to make money in this profession. And so when you can point those out to clients, because people get so married to their own story and they keep repeating it and repeating it and repeating it and repeating it, and pretty soon it's the truth, right? And to knock them off of what they perceive to be the truth, and this is not about money, it's about justice, and they get very ramped up with this sort of thing. To explain to them in front of their spouse that there's another side to this, sometimes that's easier to do in a we call it a caucus, which is where you split the people into two separate rooms to talk. But it's very interesting in mediation to be able to explain both sides of that in a way that you really can't, or there's pressure not to, as an advocate.